One of the most difficult things for a lawyer to do is to choose a remedy for his client. Now, when the client comes to a lawyer, the client has a certain story to tell. Client wants a certain outcome. It is for us lawyers to look at the whole ecosystem, to look at the whole system of remedies that could be available to the client. And when I use the word remedy, I use it in a very legal sense. So the client will come to you with a certain end goal in mind, and it is for us to choose for him or her the remedy or the recourse that is to be adopted. Of course, in the case when the client is an educated client, the client may himself have a lot of value to add in your discussion and help you arrive at a better decision. But that may not be so for a large number of clients who approach to you. And it is in that context that choosing the right remedy is very important. There is something I have to tell you there because I have a story on this. When I was reading about the scope of 226 back in the year 2006-2007 when I was still studying law, one of the issues that came up was the scope of the writ jurisdiction. And the reason why it really struck a chord with me at that point of time was because my father himself was a businessman, and he used to get stuck in government contracts, getting some payments released from the government. And what he felt and what I could also understand at the time was that the conduct of the government was really arbitrary, in the sense that for no reason the payment would be stuck for a long time. They would say funds are not available, funds will be allocated, and for all of those times the fund would be stuck. Now, and for any government contractor, payment getting stuck with the government is a very done thing. I mean, done thing in the sense is a very common thing. So at that point of time, I studied the case law very closely. So there was this case reported in 2004, Volume 3 SCC, to which I'll just take you through. The case of ABL International versus Export Credit Guarantee Corporation. Now, the facts of that case was, I'm trying to avoid convolution of facts here. There a certain company, a tea company, had made a supply to a corporation in Kazakhstan, and the failure to make payment was guaranteed by Kazakhstan government, which was in turn guaranteed by the Reserve, on the instructions of Reserve Bank of India, was guaranteed by the Export Credit Guarantee Corporation, ECGC. The supply was made, Kazakh corporation defaulted. The Kazakh government also said, like, we want to pay, we admit the liability to pay, but we don't have the money to pay to you. So in that situation, when the default was admitted, the debt was admitted, it really fell on to the insurance company, that is the Export Credit Guarantee Corporation, to make the payment. So the facts that I told you pertain to the facts of this company called ABL International. Interestingly, and something that I discovered several years later while doing a due diligence when I was interning in a law firm, that a similar contract was also made by Tata Tea at the time. And Tata Tea also had a same claim against the ECGC because it also made supplies to the Kazakh government. The ABL International, at the relevant point of time, that is in the year 97-98, chose to file a writ petition. And the ground in the writ petition was that we will want the state's entity, that is Export Credit Guarantee Corporation, which had really acted on the instructions of Reserve Bank of India to guarantee a performance of a contract, that is that you, a company from India, please supply to Kazakhstan and we will ensure that your payments are made, and this is to be done by ECGC. So on the strength of the argument that a writ petition will lie against ECGC for direction to ECGC to make a payment of the admitted insurance amount, writ petition was filed before the Calcutta High Court. The Calcutta High Court passed an order. From that order, civil appeal was filed in the Supreme Court, and that was eventually decided by 2004 3 SEC 553 by a bench of Honorable Justice N. Santosh Hegde and Justice B.P. Singh. Now, in that case, the court rejected the issue of rejected the argument against maintainability and held that in appropriate cases the writ court has the jurisdiction to entertain writ petition even involving disputed questions of fact, and that the bar is not absolute. The court in fact upheld the order with the direction that the amount should be paid to ECGC. Now, this was in the year 2004, or particularly, I mean, it was decided on 18th December 2003. So, in 18 December 2003, ABL International had an order in its favor against ECGC. Now, several years later, in about 2008, I think towards sometime in 2008, I found out that, like I mentioned, that Tata Tea also had a similar claim, but Tata Tea in the year 97-98 had filed a suit against ECGC for its failure to adhere to the insurance contract, and that suit later on was transferred to Bombay High Court's list of long causes. That is, it will take its own time. So, we had a case where in 1997-98, Bombay High Court, the Calcutta High Court had decided in favor of, partly in favor of ABL, and from that Supreme Court also, Supreme Court decided in favor of ABL, and the issue was settled. And in the Bombay High Court, the Tata's case was still pending. Now, at that relevant point of time, of course, filing a writ petition in a contractual matter against the state government would be in a grey area, because it's a disputed, could be a disputed question of fact whether or not the writ would be entertained. That's one way of looking at the problem. The other, of course, is to take a safest remedy and file a suit in the appropriate court, which at the relevant point of time for Tata Tea was the Bombay High Court. So, as a consequence of the choice that had been made by the lawyers at the relevant point of time for the respective parties, ABL International's case was decided. They got what they wanted, and Tata's case in the Bombay High Court was still pending in the list of long causes. So, the lesson from this is that the law may offer to you more than just what is apparent. So, as a lawyers, as you will need to look at closely for the options that may be available to you. You may have advantage of getting the law decided in a particular way, but it's really up to your ability to craft that remedy for your client. Now, in the context of the law that is available on the subject, I must say that there has been a subsequent judgment also, particularly that of Joshi Technologies, reported in 2015, Volume 7 SCC 728, in which the Honorable Supreme Court has clarified that as it is not necessary that whenever there is a money matter or a recovery of money or a property against the government is sought, or the government's instrumentalities or agencies is sought, that the writ petition would be entertained. The court has specifically emphasized that parties will need to show that in addition to the claim, which could be disputed, but there is a public law element that is involved. So, unless a party is able to show that there is a public law element also involved in a writ petition involving a money claim, a writ petition is not to be entertained. Now, so at the time when ABL International moved to the Supreme Court, or the High Court, the law was not as nuanced as it is today, but ABL International had the first mover's advantage and was able to get the law settled at the time in its favor, and countless government contractors and companies have since benefited from that. So, as long as a public law element is shown, it may be possible to craft a remedy accordingly.